Okay, so it's 4:05 and I guess we can get started.
Okay.
So thank you all for joining the event today. I am Amy Wong. I'm the Director of Operations for the New York chapter of Project by Project. Our organization is all about developing leaders and empowering the Asian American community. To kick off Asian American Heritage Month, while focusing on our civic engagement theme, we have a series of events lined up for our community. In times like this, it's difficult to have conversations around estate planning, and it's often looked as a superstition or bad luck, but these things are important to talk about. So with Holly Geerdes here today, we want to have those tough but educational conversations. Holly is one of the best trial and estate planning attorneys in the U.S. Ms. Geerdes has her own law firm specialized in asset protection and asset planning, and has been practicing for over 20 years. Most recently, Ms. Geerdes was selected as the top 100 trial lawyers in the nation by the National Trial Lawyers Association. So without further ado, I'll hand it over to Holly to kick off this educational seminar.
Thank you, Amy. I appreciate the introduction. Good afternoon, everyone. Welcome to How to Protect Your Home and Life Savings. We're going to talk about how to protect your assets for yourself and for your loved ones after you die. And for those that have parents, and if they're elderly or not, this is a topic that you need to talk about because it's going to affect you as a beneficiary of your parents' assets if there's anything left, depending on whether you can convince your parents to do some asset protection planning. So we're going to go over what the schedule is today. Now, we're going to give a little background of who we are, the Geerdes and Associates National Law Firm. Then we're going to discover the 3 steps to plan and protect your home and life savings. Again, I hope you will, after this presentation, have this conversation with your parents that probably has done little or nothing to protect the assets for themselves and ultimately have the assets to pass to the children if any remains. And then we're going to close by creating an action plan of how you actually do it. Now, when I do these webinars for certain organizations, like the organization that you guys are involved in, I do give free consultations for the people that attend and for their parents. Otherwise, I charge for consultations because obviously the time is very valuable and we're in a high demand. I will put up a Calendly link that you can click on and see what spots are available. Or Lisa and Amy, I will also email them the Calendly link and they can have it for anybody that wants to ask questions after the presentation one-on-one. I can't go into detail of every single thing that you can do for asset protection, but certainly I will talk about the general topics and how it is done. The one-on-one free consultation is for you to ask in more detail how it's actually done and whether it is an option that is available to you and your family. Now, when it comes to asset protection, this is not something obviously that you can figure out, that you can Google or do yourself. It does require an attorney to do the type of trust planning that is related to asset protection. Now, our law firm, we have copyright trades, trust and wills that are only for asset protection, and we license that to attorneys all across the United States and all 50 states. That's why I do a large part of my practice training lawyers across the United States on how to actually protect assets for their clients while they're alive and for their children after the parents die. So let's go over the general topics that people ask me about. Again, I've been doing this for over 20 years now. So I have been asked 100 different kinds of questions when it relates to asset protection. But these are the most common. And whether you are a lawyer, you're a doctor, you're a judge, it doesn't matter. Everyone is ignorant about how to actually protect their assets and how to actually use the trust to protect the assets. Doesn't matter, it comes from all walks of life. So let's go over what the topics are. The first one is Asset Protection 101. Can I protect my assets from creditors, lawsuits, divorces, remarriages, bankruptcy, disability, Medicaid, sometimes your own family? So this is called predators. Predators that can take away your assets while you're alive, after you die. So we're going to learn, how do you actually protect assets? Second, what is a trust? Everyone has heard of what a trust is, but most people, again, are very ignorant about all the moving parts of creating a trust and what it actually takes to make it work. The do-it-yourself, I can tell you a large part of my probate practice is people that do the trust themselves. I already know how that's going to turn out because a large part of my probate practice is people trying to do the trust themselves, and it fails in 100 different ways. You just don't know it until it's too late. So we're going to learn the basic mechanics of a trust and what are the different types of trusts. If you're doing the boilerplate, do it yourself, inserting your names, and you don't know what 99% of the document means, good luck. We will be seeing you in probate court. But we're going to learn what the different types of revocable trust and what the different types of irrevocable trust is. Third is, how do we avoid probate court? Probate court is the court system waiting for you to die or become incompetent or doing things wrong or incomplete. And they step in when you die or become incompetent, and they freeze your assets. And we will go over what all that legal process is. And again, for those that have parents or elderly parents, I hope you talk to your parents on how to avoid this, because you're the one that's going to be handling this and dealing with the assets frozen and the cost and the extensive amount of delay of going through the probate process to get your parents' assets when they die. Can and should I give my assets away outright? Or is there a way to pass the assets to your children protected, where your children never have to worry about losing their parents' assets that they inherit from their divorces, their lawsuits, their bankruptcy, their disability? Who wouldn't want that? Everybody should want that. But again, most people don't know how to do it because they don't even know what the options are. And second, obviously you need a specialized lawyer to do that. But if you can convince your parents, or if you've got children now, that you want to pass the assets protected to them, then we're going to learn just the general basics of it. And then we can talk about it one-on-one after the webinar. For those that have elderly parents, if you want to try to get them qualified for Medicaid, does it take 5 years to qualify for Medicaid? And is there a way to not to have to go broke or to lose all the assets or to spend all of the parents' assets before qualifying for Medicaid? So we're going to learn, how do you qualify for Medicaid and still have the assets protected while your parents are still alive, and ensure 100% that the assets will be going to the children without Medicaid taking it when the parents die. And then we talk about the power of attorney, the living will, the healthcare proxy. These are ancillary documents that you sign when you do a will package or a trust package. But you have to be careful about these documents, because these documents, especially the financial power of attorney, have no protections for people using these documents to steal your assets. Because remember, these are documents you sign allowing somebody else to take over all your assets when you no longer mentally know what's going on anymore for the rest of your life. So we're going to talk about these documents and how to protect yourself, because they're not in the boilerplate generic stuff that you download. You have to put specialized provisions to protect yourself from people taking advantage of you. And then how do we plan for disabled beneficiaries? If a few of you have disabled children, you have to do what is necessary to protect the assets when after you die, and not leaving your children vulnerable to predators and losing their government benefits, because that's exactly what's going to happen. But for a lot of us, the disability doesn't happen until after we die and our surviving spouse or children become disabled. So how do we protect the assets for our surviving spouse and children to still give them the eligibility to qualify for government benefits and still have all the assets protected for their use to give them quality of life? And finally, what about Uncle Sam? How do we avoid the estate tax called the death tax when we die? Okay, so we're going to learn, if that is a problem, how do we avoid or minimize paying the IRS 40% of our assets when we die? So what are the 3 steps to plan and protect your home and life savings? Well, first we got to know what the rules of the game is. What is the law regarding our assets if we get sued, we die, we become incompetent, or maybe we need to get on Medicaid so we don't lose all our assets? Second, how do we protect our assets from predators? And again, when I talk about predators, I'm talking about lawsuits, creditors, divorces, remarriages, disability, bankruptcy, Medicaid, your own family sometimes when you become mentally incompetent. And then what's our options to protect against these predators based on the law? So what are the rules first? Two simple rules, one when we're alive and one when we die. Most of us, when we think about estate planning, we only think about what are the rules when we die. How do we transfer our assets to our loved ones? But in reality, the rules while you are alive is more important to address than when you die. You have to protect the assets for yourself when you're alive. And if you protect the assets for yourself while you're alive, I promise you, if you do it right, the assets will automatically be protected for your children. But if you don't protect the assets for yourself while you're alive, I promise you, nothing's going to be protected for your children either. So let's go over what the rules are when you're alive. Now, when you're alive, if you're alive and healthy and competent, who controls your assets? You do. But if you're alive and you become incompetent, you have a stroke, you get dementia, Alzheimer's, what about those with coronavirus that have to be induced into coma in order to be put on a ventilator? Who controls their assets in the meantime? Just because your family doesn't mean you have any legal authority over your spouse or children's assets. In fact, you don't. So how do you have legal authority over your family member when they become incompetent? Well, if you've done no planning, we end up in probate court. Remember, probate court's waiting for you to die or become incompetent, and they step in. They're the only ones, the court system, that can grant legal authority over somebody else's assets when you've done no planning. And when you petition to be or having the legal authority over somebody else's assets, you have to go to probate court, hire an attorney, and petition to be what? Well, if you petition to be just the guardian, that's not over legal assets. That's just over daily decisions. You have children that you put as guardian in a will that has nothing whatsoever to do with your assets for your children. The court decides who's going to control the assets until your children turn 18. So a guardian is only over daily decisions, not over assets. So not only do you have to petition to be the guardian, but you also have to petition to be the conservator over the assets. So what does the court do in the meantime? Because they have to investigate you, and that takes time to see if you are legally responsible to take over somebody else's assets. Well, the probate court appoints a guardian, court appointed, a conservator, court appointed, a lawyer to make legal decisions, court appointed, and a doctor, court appointed. And who pays for all that? You do, not the court. And who ultimately makes the decision? The court. If you're in New York, ain't gonna appoint family members unless you've got nothing, because they get statutory fees every year to manage somebody else's assets. So New York, don't even bother, because you're not going to be appointed. But you got to get legal authority to start managing the assets. So hopefully after this, you will do the proper planning. Now, what if you have a financial power of attorney? Are financial power of attorneys all the same? Of course not. They're different. I can't tell you how many times people come into my office, their parent is incompetent or their spouse, and they want to do some asset protection planning, and they bring in a financial power of attorney. It's the wrong one. Doesn't deal with incompetency. You've got the generic boilerplate stuff that you download. Doesn't deal with incompetency. So we have to end up going to where? Probate court. And then I just went through all the legal process and the cost that happens when you have to end up in probate court for incompetency. Now, what if you have the right one? Does it always work? Sometimes it works. Sometimes it doesn't. Banks, financial companies, a lot of times they want you to use their own form. But when do you find out you have the wrong form? When it's too late, because you never asked that question. Why would you? A lot of real estate closing attorneys will tell you to go to probate court because they don't want to deal with incompetency issues. They don't want to be legally liable to determine whether, ooh, that person's incompetent or not, and therefore this power of attorney can be used. And second, family members take advantage of people all the time with power of attorneys. So we'd rather tell you to go to probate court because we don't want to deal with that legal fight. Now we're going to talk about a trust that alleviates all of these what ifs about the incompetency, but you've got to do the proper planning, because I can't tell you how many times people come in and they're scrambling to do planning because the person's incompetent, but they have the wrong document or no planning at all. And then it gets really expensive and time consuming to deal with that issue without proper planning. Now, what are the rules after you die? Well, every government in the universe has rules of where to transfer your assets upon death. Most countries you don't get to decide. But in the United States, you do get to have control, so long as what? That you do it properly and legally compliant. Now, where did the vast majority of people end up? Well, this is the category: no will, no trust. And even the people that have the will, or they try to do the trust themselves, or the lawyer does it wrong, they end up in this category anyway. So what happens here? Well, if you end up in the no will, no trust category, well, the government freezes the assets. The assets can never be transferred to the children automatically without going through probate court. The assets get frozen, everything gets publicized. It takes about 1 to 2 years because we have to notify everybody in the universe. Did this person owe you any money in their lifetime? And the average expense can range no less than 5% to even up to 20% or more if there's litigation. And if you become incompetent, we just went over where you end up in probate court when you're dealing with trying to get legal authority over an incompetent family member. And you don't get to decide where the assets go in this category. Surviving spouse, depending on the state that you die, your surviving spouse only gets 1/3, but no more than 1/2 of the assets. And if you've got assets in other states, you got to go through probate court in every state that you have assets. So no planning is very expensive and time consuming in the end, or when you become incompetent, because remember, this isn't just about when you die, when you end up in probate court. Now, what about the will? Does a will solve all the problems? Not in the United States, it does not. The will is no different than a no will in the United States as to the legal process. You cannot transfer assets to your children automatically with a will. You have to go through probate court. In some states, surviving spouse, okay, you have a property, husband and wife together on title, there's no automatic right of survivorship. And even if there was automatic right of survivorship between spouses, it does not deal with incompetencies. And it does not deal with when you have property in LLCs, S Corp, or C Corps. There is never, ever, ever a right of survivorship within a company between husband and wife. When one dies, you only own 50%. And if you try to sell what's the company, you could be sued for it because you are guaranteeing that you are the 100% owner when in fact you are not when a spouse dies. Now you could get away with it, but I've had spouses sued by buyers that back out of a contract and they find out that you really were not the 100% owner. Now with the will, again, everything gets frozen. You end up in probate court when you die or become incompetent, same expense, same time consuming. Now, same thing. If you've got assets in other states, a will doesn't do anything for you. You've got to go through probate court in every state that you have property. So what's the difference? It's got to be a difference. Well, there is, the last part. You have a document now that you can present to the probate judge where you wish your assets to go, what remains after everything is done. Now that's a wish list because that's assuming nobody fights. So if nobody fights, good. Then the beneficiaries listed on the will would get the remaining assets. But if you got multiple siblings, you've got remarriages, cohabitation, same-sex couple, multiple children that don't get along, good luck. That's where the fight starts to happen and the gloves come off. Now total up everything you own, multiply by no less than 5 to 20%, and decide. Do you want a no will, and we'll talk about a trust next. But before I go into a trust, if you've got any assets that have debt on it, houses, mortgages, they have to be liquidated to pay off the creditors and the lenders. So if you've got parents, they've got debt in businesses or property, and you as a child would like to inherit it, not going to happen in probate court if they die with the will or no will, because the creditors have to be paid in full. So if you want to avoid this situation, then you got to do a trust. A trust is the exact opposite of a will and a no will. When you have a living trust document, that document transfers assets automatically, instantly, privately, no cost involved at the end, to what? The spouse, to children, and so on. If you have a will, every time somebody dies or becomes incompetent, we end up going through probate court. And if you've got assets that have debt, guess what? We're not in probate court for them to tell us to liquidate and sell off everything to pay the creditors. The children and the spouse can take over with the trust document and decide how they want to deal with the debt. They don't have to lose the assets or the business because of the debt. So no assets frozen, no probate court involved, no probate expense, no delay. And if you become incompetent, you can take over the assets. If your parents become incompetent, you can take over as alternates so that you don't have to go to probate court to manage your incompetent parents' assets. And if you've got property and businesses in other states, you can manage it all within the trust without going through probate court in every state. But that's assuming you set up the trust properly, and you fund the trust properly, and you maintain the trust properly. Now I'm going to go back to the mechanics of a trust, but let's talk about this financial power of attorney briefly. This is a document where it's a laundry kitchen sink list of everything you could possibly own. And you appoint an agent. So eventually your spouse isn't going to be alive and your children or somebody else is going to have to step in. Now, when you give me a blank check and sign it, what can I take from you? Think about it. What's in your bank account? But if you give me a power of attorney, what can I take from you? Everything. There's no consequence. You don't know what's going on anymore. I had an eldest son, had a financial power of attorney, the generic boilerplate stuff. The father was dying of cancer. He had sisters and brothers and a mom alive. Right before the father died, he took that power of attorney and transferred $1 million into his bank account. Now, mind you, he still had sisters and brothers. Now, what he did, was it criminal? Nope. Was it illegal? No, because it was a generic boilerplate stuff. And he knew he could get away with it. And the brothers or sisters are asking, bring it back. It's the parents' money. Nope, sue me. Come after it. Good luck. Because it wasn't illegal. It was totally allowed in the generic power of attorney. Now, mind you, what do we get to do in the United States? Anybody can sue, even if it's frivolous. So, of course, we sued the eldest son because they had money to sue. But how many of you have money to sue? Most people don't. So we sued the eldest son, and we got part of the money back as the settlement. But it didn't have to happen that way. if you protect yourself and you have the right provisions in the power of attorney, it doesn't allow people to steal money legally. Now, if the financial power of attorney had the right protections, we could have sued the bank, because the bank would have been prohibited from doing it. And the bank would have had to pay all the money back, plus damages, plus attorney fees. But the generic boilerplate document has no restrictions, no prohibitions, no limitations, no protections whatsoever. So be very careful about these documents, because it doesn't have any protections for you unless you put it in there and the lawyer knows what they're doing. Now, what about the healthcare proxy? Again, if you get sick or your parents get sick and the hospital asks, do you have the healthcare proxy or the medical power of attorney or the living will? And if you don't have it, the government makes the decisions. So make sure you have these documents. And again, make sure you customize these. I've had children, brothers and sisters, fight over what they thought the parents wanted as to the life and death decisions and medical. So if you don't make it clear, guess what? Everyone has their own personal opinion about what they think the parents wanted. I've had brothers and sisters never like each other again because of these crisis decisions that they argue about between each other and amongst each other as to what their parents, they think they wanted. Now, who's the predators out there? These are the top four. The government, of course, long-term care costs when it comes to elderly parents, your own family, and of course, we're in America, we can sue for anything. So what about the government? Well, if you've done no planning, you end up in probate court when you die or become incompetent. Or Medicaid, you think your parents qualify for Medicaid? Okay, but guess what? If they've got assets, Medicaid takes it when they die or sooner. What about Uncle Sam, the estate tax? Well, the current exemption amount is 11 million, and I'm just rounding off. With inflation, it's currently 11.5 million. If you have assets above that line, you have to pay the federal government 40% of assets above that line. That's only 1% of the population. So if you have assets below that line, you don't owe the federal government 40%. But that estate tax line changes. We don't know what it's going to be when you die or your parents die. I can tell you in 2026, it automatically drops down to 5 million, which includes the death benefit of a term policy or life insurance. And the way this economy is going, it'll be less than 5 million, I can tell you that. So any assets above, and it's been as low as 1 million. So if you have assets above 1 million, you got to pay the federal government 40% of the assets above 1 million. And some states have an additional state estate tax on top of the federal. So not only would you owe the federal government, but you got to also owe the state. Massachusetts, it's 1 million. New York has a separate estate tax too. Look at in Minnesota, the singer Prince, Purple Rain. He died with the $350 million estate, did no planning. So within 9 months of his death, the federal government got 40% of that $350 million. On top of that, the state of Minnesota got another 16%, automatically within 9 months for lack of planning. So again, lack of knowledge, lack of planning, in the end gets very, very expensive. Now, what about long-term care costs? For some of you that are young, get long-term care insurance if you can, because this day is coming for all of us. 70% of those 65 years or older in the United States will end up in a nursing home. So if you can afford long-term care insurance, life insurance with long-term care rider, get it, because it's going to prevent you from going broke or using up all your assets or having to be stuck with Medicaid. Nursing home is $9,000 to $14,000 a month. How many of you have $9,000, $14,000 a month? And even if you did, why would you want to use that just for the shelter, the nursing home, not for any of your other bills. If you want to stay at home, it's over $18,000. If you want good care at home, it's over $24,000. I can tell you that because I have clients that pay out of pocket every month for home care. Their children can't take care of them because guess what? You got to work. You've got your own family. A lot of them live in different states. So this long-term care is a crisis for everyone. You are never too young to start planning for this because eventually you're going to get too old, unhealthy, and it's going to be too expensive. The average stay in a nursing home is 3 years, 3 to 5 years. And those with dementia, it's over 8 years. So imagine that long-term care cost for over 8 years. My grandmother with dementia was in a nursing home for 15 years. So for those, if you have parents and they're thinking about how do we qualify for Medicaid because it's too late for them to get long-term care or it's too expensive. And most parents don't want to go broke and not have anything to give to their children. But that's what's happening. Or Medicaid's taking and children are like shocked when their parents die that the state Medicaid has a lien, an invisible lien, because you won't know it until your parents die if they're on Medicaid in a nursing home. So how do you actually qualify for Medicaid and still have all your assets protected to ultimately pass it to your children? Medicaid doesn't require you to be poor. You just have to have the specialized lawyers do the right type of trust to protect the assets just in case your parents end up in a nursing home in the future, and then they can qualify for Medicaid, and Medicaid won't touch what's in the trust. So again, Medicaid is very complex. You also don't have to put it in your children's name because there's a lot of bad reasons to put it in your children's name. It's not because they're bad. That's not the reason. When you put it in your children's name, guess what could happen? They could die before you. They could get divorced, and then their ex-spouse gets what you gave them instead of protecting it for your children. What if your children get sued? Your children would have preferred you to pass the assets protected, not give it to them, and then they get sued, and then they lose it. And then there's capital gains tax consequences for putting assets in your children's name while you are still alive. Versus if you put it in the right trust, when you die, your children get all of the equity of your property and businesses tax-free. So if you can pass the assets to your children, well, not only do they get it tax-free, and I'm not talking about the estate tax, I'm talking about equity, capital gains, and you can pass the assets to your children protected from their creditors, lawsuits, and divorces, they would prefer that. Not passing it to them while you're alive just because you want to qualify for Medicaid. Well, guess what? A lot of times that doesn't work. And then they've got capital gains tax to pay when you die. And they could lose it to things that are uncontrollable in their lifetime. So I will talk briefly about the type of trust, the Medicaid, that you can do where it's protected for you and therefore it's protected for your children. So what is the options? How do we actually protect the assets for you while you're alive and also for your children and surviving spouse? Well, if you do no planning, it gets extremely expensive and time consuming at the end, or when you become incompetent or you get sued or you want to qualify for Medicaid and you can't. So how do we actually protect the assets using a trust? Well, let's talk about how do you create the document called a trust and the mechanics of how it works and what are the different types of trust. First, when you create the document called the trust, you, the owner of the asset, create the document. You, for most trust, are the beneficiary. You do whatever you want with your assets while you're alive. And then you are also the trustee, the one that controls it while you're alive. Now, when you die, you'll name an alternate trustee to control the trust, and you're going to name alternate beneficiaries who can use the trust assets after you die. But once you create the document, you're not done. If that's all you do, It's a useless document. Doesn't mean anything. Might as well not have anything. Can't tell you how many times we probate people that have a trust document, but they didn't put anything in it. They retitled the documents wrong. You can file a deed for any reason, and it could be completely wrong. No one, that's not the clerk's job to tell you that it's wrong. And then when do we find out? When it's too late. So retitling the assets is technical, but you got to do it and put it in the trust. Otherwise, all your assets are outside unprotected to go through probate court. So when you create the trust, you got to retitle everything into the trust properly. Once you do that, when you die, it automatically, instantly, privately, no further cost, goes to you, who? Surviving spouse and children. It's so simple at the end if you do it right. Now, what are the different types of trust? Well, again, these are categories. And in each of these categories, there are many different types of trust. The revocable category is the most popular. If you hear about people having a trust, it's probably the revocable trust. You control everything as a trustee. You do whatever you want. You're the beneficiary. You can amend the document. We don't need a separate tax ID because this is your alter ego. This trust is your nickname. While you're alive, nothing changes. But when you die, this document transfers the assets automatically to your children or whoever you designate, automatically. If you don't have the trust document, we got to go where? Probate court has to deal with transferring your assets. And this trust, because it's your alter ego, your DBA, your nickname, we don't need a separate tax ID. The law doesn't recognize this trust any differently between you and this trust. Now, the irrevocable tax avoidance, remember the 1% of the population that has assets over 1 million? Well, they use this trust to put assets above 11 million so that they can stay below the line. And when they create this document, they name normally the children as a beneficiary. And then they can't touch it anymore. They can't be the trustee. It has a separate tax ID. It's a completely separate entity from you. So you no longer can ever access anything in this trust and you can't change it. So again, why would you want this type of trust? Well, if you're gonna want to avoid 40% to pay the federal and maybe the state IRS, it's a pretty good reason to do it. Now, because you don't own the assets in this trust anymore when you put it in here, of course, if you get sued or you want to get on Medicaid, nobody can get anything in this trust. You don't own it anymore. But what about the 99% of the population that doesn't have assets above 11 million, but we want asset protection from creditors, lawsuits. We want to qualify for Medicaid. Well, the hybrid middle trust. If we're not trying to avoid the IRS, we can do a lot more things when it comes to asset protection. In this trust, if you want protection from creditors and lawsuits, or in the future, maybe your parents need to qualify for Medicaid, there are different categories or different types of trust in this category for that purpose. And in this category, you can be the trustee. You can amend it. You can control the assets and manage it. You don't have to, like your parents. Ooh, how do we get this trust without giving up control? So you can talk to your parents and say you can still control it and still be prepared in the future if you ever end up in a nursing home and we want Medicaid to pay for it. And you can amend this document as to the beneficiaries and the trustee. But if you get sued, or if you want to qualify for Medicaid, they can't touch anything in this trust. So most people, they'll do the asset protection trust, especially senior citizens, or they have the revocable trust if they don't need Medicaid, or some do combination of the revocable and asset protection trust. So whatever trust you do, you can have one or combination. Now, how do we actually leave assets to our surviving spouse and children? Let's look at a case study. Whether you do a revocable trust or asset protection trust, you have to decide, or your parents have to decide, do we want to give it outright, or do we want to give it to our loved ones protected? Whether you do it in a will or a trust, you have to decide that. But most people only know the first option, just generic boilerplate to my loved ones outright. If you do that, you just have to remember, if my surviving spouse or children get sued, my assets that I give to them upon death can be taken away by their lawsuits, and it happens all the time. Look at this coronavirus. A lot of businesses are going to fail and have to declare a bankruptcy end of the year into 2022. And a lot of them use their parents' assets, the inheritance. It's going to be gone by lawsuits, creditors, and bankruptcy. If your surviving spouse gets sued, divorced, remarried, think about this. When one parent dies, a lot of times the surviving spouse remarries. And when do the children find out that they're disinherited? By the new spouse and their children. When it's too late. I can't tell you how many times children find out that they have nothing. Because when their parents remarry, the new spouse changes everything secretly. And you don't know until after the parent dies that you're disinherited. So, remarriages and divorces, if you just give it outright, gone to new spouse, ex-spouses. And what if your surviving spouse or children get disabled or ends up in a nursing home? Could be gone. They're not eligible for government benefits either. But if you pass the assets protected, if your children or surviving spouse ever get sued or bankrupt, your assets that you give to them will be protected for them forever. They will never ever lose it. It's only for them. If your surviving spouse gets remarried or your children divorced, nobody can take away your assets to them in their divorces or remarriages. And if your children or surviving spouse gets disabled, they can always be eligible for government benefits and still have all your assets to give them for quality of life and still have access to government benefits. So think of it this way. Create your family vault right now. Protect the assets for you and your family right now. And when you die, you pass that key to that vault to your surviving spouse. And your surviving spouse is the only one that can go in and out of that vault. And when the last spouse dies, you pass that key to your children, and nobody except your children can go in and out of that vault using the assets, no matter if they get sued, divorced, bankrupt, disabled. So whether you do a will or a trust, customize it. Put your protections in there. And if you do a trust, make sure you properly fund it and do it right. And you got to maintain your trust during your lifetime. Now, again, for those that have attended this webinar, you do get a free consultation. If you already have a will or a trust, I don't care, I'll review it. If it's good, great. At least you have peace of mind that it works. If there's stuff that's wrong, then we'll see if it's fixable, or we'll go through other different options. Now I'm going to open it up now, Lisa and Amy, to Q&A. And I will also, let's see here. Amy, Lisa, do you want to open it up to Q&A now?
Yeah, we can open up to Q&A. So does the audience have any questions they would like to ask?
Yeah,
Holly?
they can either ask chat, or you can just unmute everyone. It's whatever you feel comfortable with. And is there a chat part here?
Yep, there's a chat box. If you look below, there should be a chat. But I mean, they can unmute themselves, or they can ask in the chat box, whatever they're comfortable with.
Okay.
Actually, I don't really have that many questions, actually, trying to.
Okay. What's your question?
I mean, I don't really have that many questions, actually. So
Okay.
it was a pretty thorough response.
Actually, I actually have a question. So you said that we shouldn't leave our trust to our children, but then if it's not to our children, what's another best
No, that's
option?
not. Let me clarify
Oh,
that, Amy. It doesn't mean you leave it to the children. Leaving it outright,
uh-huh.
right? No protection, or you leave it protected. So
But we
you
could
can
still
just
leave
say,
it to
here,
our,
everything to my children with no protection. Or you can give it to your children and indicate, I'm paraphrasing, it's not that simple, but where you say, under no circumstances will my children's creditors, lawsuits, divorces ever take away what I leave my children. If you've got, let's say, life insurance for $1 million or term policy for $2 million, and you got minor children and you name them as beneficiary. Well, first of all, minors can't get any death benefit. The insurance company is going to require you to go to probate court, and somebody's got to be appointed to manage that death benefit unless you appoint somebody in the trust. So you could have a complete stranger that could manage that because you can't do it in a will. Second, are you going to leave, let's say you have a term policy or $1 million. Are you going to let your child at age 18 get everything lump sum? I wouldn't. They're going to lose it. Or predators are going to come and start taking, right? You got to put some protections in there. That's too much to give even to an 18-year-old. You want to give it to them, but make sure you protect them.
So do you have any recommendations for young adults with no children? Like who should they leave their assets to?
Well, I have a lot of young people that have trust because they already got properties and assets, even one property, but they leave it to their parents, their siblings, and then we just amend it when they have children.
Okay.
Okay, it's better than leaving it to having government take it. Is there a limitation to how many trusts you can set up?
Oh yeah, Holly, I'd like to clarify that question. So basically what I'm trying to ask is like, if you have a 401k and the life insurance policy and you have the designated beneficiaries already, and something happens to you, right? So the designated beneficiaries, will they be able to get those proceeds without having to go to probate court?
Correct.
And okay.
Correct. If you put a
So-
beneficiary, okay, assuming they're alive and competent, okay, if they're not alive or they're incompetent, it can't be released yet until you go through probate court. But assuming they're alive and competent, then it automatically goes to them. So
Okay.
the only question, though, you have to ask yourself is beneficiary designation avoids probate court if they're alive and competent. But if you want any protections for minor children or whoever, you can't do that in a beneficiary designation.
I see. So other creditors or like a spouse can lay claim to those those assets, but if you put it in a trust, would you be able to protect your asset better that way rather than just having the beneficiaries designated through the 401k process or the life insurance process?
What do you mean, like surviving spouse or whatever claim? Can you clarify what you mean?
Yeah, so if let's say the proceeds from, let's say, my 401k or my life insurance, right, goes to my child, and my child is married, and they end up, and my child and his wife gets divorced. So would the wife be able to lay claim to those
Absolutely,
assets?
it's not premarital.
Okay.
If you give it to them just outright, once it hits their hands, their bank account, it's their personal property. It's not, yes, it's an inheritance, but it's their personal property subject to their divorces and lawsuits. unless your trust has asset protection provisions. So for a lot of you in this organization, you have parents that you're going to be inheriting assets. And I hope you have this topic with them, because they would want to make sure that whatever they give you is protected from your divorces and lawsuits, so that you're the only one that can ever use the assets. Nobody's going to force you to give away your assets. So if you've got parents, go talk to them, and hopefully you can convince them to do the planning where you not only guarantee that you're going to inherit it, but that it's going to be protected for you. Nobody can take it away from you. Because I can tell you, majority of children lose their assets that they inherit from their parents. Lawsuits, creditors, divorces, number of reasons. But it doesn't have to happen that way. You can get everything from your parents, and it will be your safety net for you to use only for the rest of your life, to ultimately pass to your children with the same protection.
Okay.
Oh, sorry, Lisa, go on.
Sorry. So would it be reasonable to set up like a trust for like the larger real assets that you have, like maybe a house or like a car or whatever apartments you have? Would it make sense to set up separate trusts for those, or one trust with?
No, it's just one trust for all your assets that you want to put in it.
Okay.
So normally people put their properties in there. And then the life insurance, the bank accounts, you put the beneficiary as the trust. If you put asset protection provisions, right? Because the only way your children get the assets protected is to what? Get it through the trust.
So within the trust, can you designate different assets to different
Yep.
child? Okay.
Yeah, it's your master plan. You get to decide however you want to give it to your children.
The asset protection trust, isn't that irrevocable?
Correct. But it doesn't require a separate tax ID or separate tax return. And I'll tell you why we do that. Again, this is trademark trust for our trust. We do that because a lot of our clients, the parents, for example, New York, they bought a property maybe for $300,000 20 years ago. It's worth several million now. And they want to make sure that their children get the property without having to pay any of the capital gains tax on the equity when they die. So we got to still maintain the tax ID under the parent's name for that trust. Okay? We can't put it in the children's name yet, or a separate tax ID. So that is still a grantor trust, because most of our clients want to pass the property and businesses to their children, so that when they sell it, they don't have to pay any capital gains tax on the equity. It's huge. So that is our own copyright trust that we do for that specific purpose, because they want their children not to have to pay any taxes.
So is it also true that there's certain states that have no estate tax, and that's why certain people just choose to die there instead?
Well, what I was just talking about had nothing to do with estate tax.
Oh.
Okay, that has nothing. I'm talking about when your parents bought a property for $100,000 and now it's worth $1 million. When they sell it, they have to pay capital gains tax on $900,000 equity. If they put the asset in the children's name while they're alive, when the children sell it, they got to pay the capital gains tax on $900,000. But if we do that asset protection trust, okay, when the children inherit that property upon their parents' death, they get a stepped up tax basis to $1 million. And when they sell it, they don't have to pay any capital gains tax on that equity. They get it tax free. That's a separate issue from the estate tax.
Okay, thank you for clarifying.
Mm-hmm.
Are there any other questions for Holly? Okay.
Yeah, what do you charge for consultations? Is it $500?
Yes, I generally do. But again, for those that have attended this webinar, I've agreed with Lisa and Amy to give you one-on-one free consultation for any questions that you may have for yourself or for your family. And we do it through Zoom, obviously. We're not going to meet in person during this time. And so we'll just set up a Zoom. And I had typed in through the chat, and I'll do it again. There's a Calendly link where you can see what spots are available for one-on-one. And it's informal. We just talk about what your questions are, more specific to you or for your parents or family.
And then what's the average cost that you charge for an irrevocable versus a revocable trust?
Oh, it really depends, because there's many different types and we customize it. So the revocable trust can start off as low as $1,200 on up. But same thing with the irrevocable trust. Of course, it's more expensive. It just depends. And it's not based on how much assets you have. That would be unethical. It's based on the type of trust that you pick. Now I see here from Christina, so the inheritance you receive may be subject to divorces. Yes, of course, if it's not protected. Prenups don't help. Prenups don't help. I'll tell you that. I have taken away many children's assets on behalf of my clients, even when there's a prenup. First of all, your parents' assets, if they give it to you unprotected, is not premarital. Second, prenups only work if you follow the rules. And what happens to your marriage? You waive your rights by your conduct. You commingle your assets. There are many different ways why prenups don't work. But if you have assets that you have before marriage, right now, I suggest you do a trust, even a revocable trust, because that's better than a prenup. As long as you keep the assets in the trust, you do the transactions in the trust, buy, sell, whatever. Even if you use it for your spouse, like you buy a house in the name of the trust, and you live in it with your spouse, it's still separate, because the trust is a very, very bright line rule that it's still in your name, in your trust. I have a lot of clients where the parents bought them assets or they have joint assets. And when they're thinking about marriage, we do a trust immediately. Next question.
Does anyone else have any more questions for Holly?
Now we do,
Kelly asked, is there inheritance part specific to New York?
well, New York doesn't have inheritance tax. They have state estate tax, and it matches the federal. New Jersey doesn't have estate tax, but it does have inheritance tax, but only if your beneficiaries are outside your bloodline, if you're giving it outside to your nieces and nephews and sisters and brothers. But if you're giving it to your spouse and children, there's no inheritance tax. And then what is the range of pricing for wills? Well, wills can range from $500 on up, depending on how complex it gets. And then I already said trust can range from $1,200 on up. I can tell you any trust is cheaper than probate. Any trust is cheaper than losing the assets. Okay.
How much would probate usually cost?
Probate ranges from 5 to 20% of the value of the assets.
Wow.
Yeah, it gets super expensive. So either you pay nothing now or very little, but you pay at the end. We do wills all the time for a specific reason. And I'm not going to go into that because there's complex reasons for that. But wills are cheap for a reason, because you haven't done hardly anything. But it's better than nothing. And you can start off with the will, but I hope as you progress in life, or you already have a property, that you do a trust. And you do the trust properly, obviously, because again, like I told you, a large part of my probate practice is all these people that do the trust themselves, and it fails for 100 different reasons. Because they just do it wrong, they don't maintain it. There's a moving parts to a trust because you maintain it during your life. Now, for those, we do webinars for those that want, like your parents, want to hear it in Mandarin. Okay, because our office in New York, which is in Chinatown, we always get requests to do webinars for the clients that want to hear it in Chinese. And if that's something that you think you guys want for your family or your relatives, then Amy and Lisa, you can just email me and I can tell you the next time we're going to do it in Mandarin.
Do you have anyone for Cantonese as well?
No, for Mandarin, but for one-on-one consultations, we do it in Cantonese.
Oh, okay.
But the actual presentation is in Mandarin.
Gotcha. And then Jenny has a question. Is the trust a one-time cost or is there a yearly cost to maintain it?
No, it's just a one-time. Now, assets changing doesn't necessarily change the terms of the trust. But for the most part, once you set up with the trust and we teach you how to do it, okay, the only way you learn it is by doing it actually with the lawyer. Because when you do it by yourself, you will never have peace of mind of whether you did it right or whether you're maintaining it right. Okay, but when you do it with the lawyer and you do it with them, then you know how to maintain it for the rest of your life. So no, it's a one-time fee, that's it.
Okay, are there any other further questions?
Okay, is that it?
All right. Well,
Thank you,
so much for
everyone.
joining.
Have a good rest of what's remaining this Sunday.
Thank you so much.
Okay, thank you, and everybody stay home and safe.
Thank you.
This session will be recorded, by the way, and will be available for everyone.
Okay, send it to me too.
Thank you.
Thank you. Bye, Lisa. Bye, Amy.
Bye.
Thank you.
Bye.